Washington, D.C. courts have some pretty strict rules when it comes to evaluating digital evidence in civil protection order cases. I'm talking about things like text messages, screenshots, and social media posts. In today's Explainer, we're diving right into exactly how you authenticate your evidence right now and how these rules are totally transforming in 2026. So question number 1, will your digital evidence hold up in court? You might have a smartphone literally full of texts or social media posts, but getting a judge to actually look at them and accept them, well, that requires meeting some very specific legal standards. In D.C. courts, they apply a standard called a reasonable possibility. Now, what does that actually mean? It simply means you have to prove it's more likely than not that your evidence is genuine. So you don't need absolute 100% certainty, but you definitely have to build enough of a foundation to show there is a reasonable possibility it's the real deal. But before a judge even looks at the value of your evidence, you've got to clear the very first hurdle, which is authentication. Authentication simply means proving that the digital evidence is exactly what you claim it to be. If you say a document is a threatening text from a specific person, you have to actually prove it came from their phone first. Show phone numbers, not contact names. A really common mistake people make right out of the gate is relying on contact names to prove a text is real. You absolutely must show the actual phone numbers. Why? Because contact names can be changed by anyone who owns the phone, which makes them completely unreliable to a judge. Visible phone numbers are absolutely mandatory because they provide hard, verifiable data that can be cross-checked with cellular providers. Step 1, use your native screenshot function. Please don't just take a blurry photo of your screen with another camera. Step 2, capture the full conversation thread to show the complete context. Don't just isolate a single message. And step 3, ensure all timestamps are visible. You really need those dates and times clearly displayed right alongside the messages. Never crop or edit screenshots, period. If you crop or edit a screenshot in any way whatsoever, it's going to be immediately challenged by the other side, and a judge will almost certainly throw it out. Any visual tweak raises instant red flags about whether you're hiding context or just completely fabricating the conversation. Okay, let's dive into this next concept, chain of custody. This is the continuous documentation showing every single person who accessed the evidence, how it was stored, and every action taken with it from the second it was discovered. Maintaining a strict chain of custody is how you mathematically prove to the court that the evidence has been perfectly preserved and hasn't been tampered with. To actually prove this digitally, forensic examiners use what are called hash values. You can think of a hash value as a unique digital fingerprint for a computer file. When someone makes a forensic copy of your original device, both files should have the exact same hash value. If someone alters even a single character or pixel in that file, it generates a completely different fingerprint, instantly revealing the tampering to the court. So what is Rule 707, and why does it matter in 2026? This is the second core question people are facing with a rapidly shifting legal landscape right now. Rule 707 is a newly proposed rule requiring AI-generated evidence to meet expert reliability standards. This legal framework was specifically built to deal with machine-generated and AI-created evidence, and the public comment period for it closes on February 16, 2026. Basically, the rule demands that any AI-generated or AI-enhanced evidence meet strict expert reliability standards before it can ever be admitted in court. Pre-Rule 707 standard, authentication only. Post-Rule 707 standard, expert reliability test required. Before this rule, you really only needed that basic authentication we just talked about to get a video or audio clip admitted. But after Rule 707 kicks in, if your evidence was enhanced or generated by AI at all, you have to pass a rigorous expert reliability test. You essentially have to prove to the court that the AI system itself is scientifically rock solid and didn't distort the truth. Now, the massive driving force behind this new rule is the rise of the deepfake. A deepfake is AI-manipulated video, audio, or text that's entirely fabricated to create hyper-realistic false evidence. Courts right now are extremely skeptical of synthetic audio, voice cloning, and facial swaps, mainly because the tech has gotten so good that seeing or hearing is just no longer believing. Rule 707 impacts AI-enhanced surveillance footage, voice analysis software, and pattern recognition algorithms. Since the D.C. Superior Court generally uses federal evidence standards as a persuasive guide, this rule is going to directly impact local protection orders. If you're trying to submit AI-enhanced low-light security video or AI voice analysis software, you're now going to need expert witness testimony to prove the underlying science is actually valid. What should someone do right now if they have digital evidence? With all these strict rules and upcoming changes, let's jump into our final core question and walk through some immediate practical do's and don'ts. Actions to take right now. Preserve the original device, document access logs, and create forensic copies. First, do not trade in or destroy your device. That original phone or tablet contains crucial hidden metadata, which is basically data telling you exactly when and how a file was created, and that proves authenticity. You also need to document your access logs to show exactly who handled it and get secure forensic copies made right away. Illegally obtained surveillance creates separate legal liability. It is absolutely critical to understand that you cannot use illegally obtained surveillance in your case, and it actually creates totally separate legal problems for you. If you install tracking software or spyware on someone's device or car without their explicit consent, you are exposing yourself to criminal stalking or unauthorized computer access charges. And this brilliantly illustrates the hard line courts draw. Legal collection involves your own devices and shared location features. Illegal collection involves spyware and unauthorized tracking. Lawful gathering means checking your own personal devices, getting public toll records, or using location features you both mutually consented to. Illegal gathering is hacking, spyware, and unauthorized tracking. One of these builds your case, and the other will absolutely destroy it. Protecting against false evidence. Preserve exculpatory evidence. Reconstruct timelines with data, and use alibi digital footprints. So how do you defend yourself against a fabricated deepfake? You immediately lock down all exculpatory evidence. Reconstruct your timeline using independent data points like credit card receipts, cell phone location history, or work emails. These everyday digital footprints act as ironclad alibis against fake claims. Deleting evidence after learning of an investigation can result in obstruction charges. The absolute golden rule here is never delete anything. As the source material explicitly warns, deleting things once you know about an investigation can trigger obstruction charges. Destroying evidence, even if it looks incredibly bad for you, creates a disastrous legal assumption that you're hiding something much, much worse. Seriously, just don't do it. Consult an attorney before using monitoring data, because the overlap between the technical side and the legal side of these cases is so unbelievably complex, you really need to consult a lawyer before trying to introduce any monitoring data like GPS logs or Ring doorbell video. Legal counsel is going to ensure that your evidence actually meets those strict DC admissibility rules, and they'll confirm that your collection methods didn't accidentally cross the line into illegal surveillance. As AI makes evidence fabrication easier, will your digital evidence stand up to the rigorous 2026 standard? With artificial intelligence making it easier to fake evidence every single day, you really have to ask yourself if your evidence is ready for the future. For more guidance on navigating this wild legal landscape and ensuring your evidence is airtight, visit LopezLawFirmDC.com. Thanks for joining me on this explainer.